Hello everyone, welcome to this MyData-TRUST Live. I'm very happy to do this presentation with you this evening. My name is Giuseppe, I'm Data Protection Officer for MyData-TRUST, and I'm very happy to be here with Winnie, Data Protection Lawyer, expert for the Canadian legislation. So in this first part of the presentation, we will firstly discuss about one key aspect of the Canadian legislation, because we are speaking about fragmented legislation. Then we will highlight on some key concepts that may look similar from the GDPR, but we will see that we have key nuances to be considered for the Canadian legislation. We will then more speak about the key aspect to consider when you would like to put in place your strategy to be compliant with the Canadian legislation. And then I will list how MyData-TRUST can help you in this mission of being compliant for Canadian legislation. So let's start with these main aspects of the Canadian legislation, the fragmented aspect of this legislation. We are speaking about a federal state, so containing 10 provinces and 3 territories. And so we have privacy laws that are enacted at both federal level and provincial level. So this is the main, I would say, layer of complexity to consider, to keep in mind. A second aspect is that these privacy legislation are specific to the sector of activity and also to the type of information you are processing. And finally, based on where your processing activity will be done, specific legislation will apply. So it's important when you would like to define your legal responsibilities as an organization for the personal information under your control, you should consider these critical aspects. So federal or provincial law, the sector of activity and the type of personal information and where your activity will be done. And so here are the law at the federal level and at the provincial level. And you see that we have the ones which are specific to the private sector and the other specific to the public sector. One important thing to keep in mind is that the PIPEDA in the Canadian philosophy, I would say, the PIPEDA is considered as the threshold in terms of level of protection. And we have at the provincial level 3 provincial laws in Alberta, British Columbia and Quebec, which have been deemed as substantially similar to PIPEDA. And this is very important. We will see in the next slide for the scope of application of the PIPEDA in these 3 provinces. In addition of that, we have 4 other provinces where health-related privacy laws, so only the laws that concern the health personal information, have been considered as also substantially similar to PIPEDA. And in these 4 other provinces, we will have actually a combination between the federal and the provincial requirements for the establishment of your legal framework in your activity. And so here we are with the scope of application of PIPEDA. As I told you, it will be a kind of threshold in terms of level of protection. And actually in Canada, it will be applied to each provinces unless this province presents a legislation considered as substantially similar to PIPEDA, which is the case for Alberta, British Columbia and Quebec. So in these 3 provinces, we will have the local law that will apply for the processing of your personal information. PIPEDA will also be applicable for all the federally regulated businesses, for all businesses operating in Canada and handling personal information that cross provincial or national borders. So as soon as you are talking about the transfer of personal information in Canada, the PIPEDA, the federal law, will apply. It will apply also to all local businesses in the 3 territories of Canada and also extraterritorially when there is a need, a real and substantially substantial connection, with the Canadian audience. So within the Canada, but also sometimes outside the Canada. And we will highlight now what are the key concepts to keep in mind. Some of these concepts will be similar, you will see, with some GDPR concept, but we need to keep in mind that we have key nuances to consider in the Canadian legislation, and now we will highlight these nuances that we have for some key concepts in the Canadian legislation.
So thank you, Giuseppe, for that nice introduction. We're going to go through some key concepts, and each time we will try to compare with the GDPR to see how it looks like, but to see that we need to go further to be compliant with the Canadian privacy laws, but also to understand that we need to not just apply what we have under the GDPR to Canadian law without further adaptation. We will start by understanding the logic of compliance within the two regulations. So in the EU, you may know that it's more a complementary approach between the GDPR, which is the text that apply all over EU, and depending on which state you're planning to run your clinical trial, or in which state you're planning to perform some processing, you need to look into the country's laws and to see what specific requirement you should add to the GDPR. It's not really the case in Canada because it's more a concurrence-based approach. What does that mean? It means that the equivalent of the GDPR, which is PIPEDA in a way in Canada, compete with the provincial laws to see what rules you need to apply. It means that first you will need to identify the provinces you want to target. So which provinces you will need to conduct clinical trial. And then you will need to ask two questions. The first question will be, okay, in these provinces, do we have a local privacy law, so a provincial privacy framework? If yes, the provincial framework should prevail to people that in principle. And then if there is no provincial law, then you will apply PIPEDA. So it means that base all your compliance strategy on PIPEDA only, without even further assessing where you are going to perform clinical trials or the provinces, is partially wrong because you may miss some provincial specifics. Now we will go on the actors. First thing, we will discuss about the concept or notions, I will say, of data protection officer and privacy officer. They may look like the same person, but in reality there are some nuances. It's true that in EU and Canada, those two actors are advisors, right? So they will help company in their compliance journey, they will provide advice and guidance, but the nuance come when you go further. For example, in EU, the DPO can be internal or external. And in Canada, the privacy officer is internal, so it's the face of the company towards the authorities and towards the data subject or the concerned individuals, as we call them in Canada. So it should be someone internal, a C-level person, or the person with the highest authority. So it's more about accountability, right? Because the DPO in EU is not accountable, so he's only an advisor, and the organization, so the data controller in EU, retain the responsibility regarding the authorities regarding compliance. In Canada, the privacy officer will be accountable, so he will be the one responding to the questions of authorities and of concerned individuals. Something also interesting is the fact that the Canadian privacy laws gives the possibility to delegate the advisory role to external person. So it means that you as a company wishing to conduct clinical trial in Canada, you will need to appoint someone internally to be your privacy officer, and then to delegate the advisory role to an external company. So an external company will help you navigate through the law, but in the eyes of the authorities, you will be the one responding, so the one accountable. Now, let's go to the requalification of trial sites. is really important because in practice it may delay discussion or negotiation with sides. So it's really important to use the right terminology or the right word qualification, okay? In EU, you will see that mostly we are dealing with joint or independent controller depending on the country, or a relationship controller processor where the child sites are processor depending on other country. Those terminology may not sound familiar with your Canadian side because they will be used to other language. And language here is really important because even if at the end those means the same, it may, involve delay in negotiation and in discussion. So it's important for you to know that, for example, in Ontario, instead of calling the hospital control in your CTAs or in your contract, you will call them health information custodian. So again, terminology is also important here. Another thing to clarify is the definition of personal health information. The basic definition is data revealing health status. I think it's the more common definition, the more classical one, and it's the definition that is really similar to the EU GDPR, right? So it means that if you define health data within your contract as data revealing health status, it's okay. You are compliant with the PIPEDA, for example, so the federal law. But don't forget that you have some specifics, right? You have some specific in provinces. For example, in Quebec and in Ontario, all the data, including regular data, that a sponsor or that study staff will collect for the purpose of clinical research is per se health data. So the age of the patient, the name of the patient are per se health information. So it's really important to know because based on the qualification you give to the data, you may need to implement more strict or less strict obligations or rules. And now let's talk about I think this one is really similar in the EU and the GDPR because the definition of pseudonymized data in EU and in Canada is quite similar. The only difference is the terminology. So in Canada you will see, for example, de-identified information, but it's the same thing. So it means that you are dealing with data that help to identify an individual indirectly, so through a code or an ID identifier. Anonymization also quite similar in Canada, but the advantage is the fact that compared to the EU GDPR, the interpretation is not so strict or is under construction, under discussion, both at the federal and at the provincial levels. But what you need to understand here is the fact that anonymization is considered as the fact that you cannot identify directly or indirectly someone from the information you have in hand, but also from the information you may use to combine with the information you have in hand. So those information may be otherwise available. So similar definition than EU GDPR, but under construction.
Thank you very much. It was very clear and important to highlight these key nuances and to do this parallel for this key concept between GDPR and the Canadian legislation. Let's talk about the compliance now for the Canadian legislation. So from the PIPEDA, we have 10 key privacy principles to respect and take into consideration that are listed here in your screen. So some principles will give are related to a right for the concerned individual. Some give key responsibilities for the organization who control some personal information. The main, I would say, privacy principle here that we should consider, and I will emphasize on this key principle, is the accountability principle, which states basically that an organization is responsible for all the personal data under its control, even if the processing of this personal information is done contractually with other service provider, even when it's outside the province from where this personal information are collected. So this gives to the organization implicitly a lot of, I would say, requirements, a lot of responsibilities the organization should comply with. You can see that, in addition of that, some of these principles look similar from the EU GDPR. We are speaking about purpose identification, about legal basis, safeguards, limited collection, and so on. And actually, if maybe you are already an organization with activities in EU, you are already aware about EU GDPR principle, and maybe you are already compliant with the EU GDPR. But pay attention, because it's not because you are GDPR compliant that this necessarily means that you are compliant with the Canadian legislation. We have differences, and now Winnie will explain you in details what are these differences between being compliant from a GDPR perspective and being compliant from a Canadian law perspective.
So, thank you, Giuseppe. So I think the key message here is to know that, okay, compliance within GDPR rules is really similar to the Canadian one in principle, but you know the devil is in the details, and you need to go further and to see the real, differences. And this is what we're gonna do. So to emphasize that and to illustrate that, we created that slide. On the slide, you can see in the left bar, so the vertical one, the effort for Canada compliance. So it means that if you are already GDPR compliant, what's the extra effort you should put in place to be also Canadian compliant? In the horizontal bar, you see the risk of non-compliance with Canadian privacy law if you just apply GDPR obligations without customizing it for Canada. So here it's really for the organization that are either already GDPR compliant, but or also in their way for GDPR compliance. The first point we wanted to illustrate is exercise of rights. Really similar, highly similar to the GDPR, with the deadline that can be extended with justification, or for example the fact that you should provide or answer to the request or provide access to the data with no cost except few exceptions. So if you just apply your policy regarding the way you should consider the data subject request to Canada, in principle it's okay. So low effort, low risk of non-compliance. But it may change, as we explained, depending on province specific. For example, you will see that if you just apply the rules of GDPR in Quebec without taking attention of the fact that after 30 days, no answer means refusal to grant the request of the concerned individual, then you may be on a higher risk of non-compliance, because in Quebec you will not have the right to extend the initial period to answer data subject. So you see, here you will just adapt details, so minimal or low effort, but if you don't do it, you have a high risk of non-compliance. Second point, legal basis for clinical trials. Again, here I think for some countries, for example, where you need to use the explicit consent for clinical trial, it is okay if you just apply it in Canada, because in Canada you need to collect patient information for clinical trials, provided that they have, you collect the explicit consent. So they will match. However, for other category of data subject, you may need to adjust a bit. For example, there is no, so the contractual, the legal basis based on contract doesn't exist in Canada. You need to rely on implicit consent, so implied consent, sorry. So you will need to adapt at the end of the day. It will require less effort, because you will just need to adapt, for example, your SOPs or your policies, or your ICF, etc. So again, less effort for Canada compliance and less risk of non-compliance with Canadian privacy law. But that may go, I would say, that may be more and more complex when we go to individualized informations. Why? Because in Canada, you will need to provide more information that in certain way, more information than the one you are mandatory to provide under EU GDPR. For example, you will need to provide the contact detail of the privacy officer, so the person designated to be accountable, so to be the face of your organization in front of the data subject and the authorities. But you will need also to describe clearly if you are using an AI tool to collect personal information of individual. You will also need to describe clearly how the AI tool works and to explain the user how he can do, to disable all the options that may be intrusive to his privacy. So extra legal requirement. And last but not the last yet, but the data breach notification also is really important because also here you have some details to consider. For example, under the GDPR, you have two layers to see, two layers to assess if a risk is sufficient to be, notified to the authority or to be communicated to the data subject, right? In Canada, it's not the same. You have one layer, one threshold of assessment, and if it's a potential high risk, you need to notify to both the authority and the data subject, concerned individual. So it means that if you just apply the EU GDPR rules here, you may be in breach because you may not communicate the data breach to the data subject, thinking that the second threshold of the GDPR also apply in Canada. So here you will be, the risk of non-compliance will be even more, it will be higher, sorry. The last point is about data transfer. So data transfer will really require from you a great effort, but also at the same time, if you don't implement it, you will be, you will have a higher risk of non-compliance. Why? Because data transfer in Canada has a completely different definition. I think Giuseppe will also explain it later, but for example, even disclosing information from one province to another is a data transfer. You will also see that the methodology for transfer impact assessment are different, but Giuseppe will come back on that again later. Now, something also interesting is the relation with the Privacy Commissioner. You should know that in Canada, the approach, the process or the way authorities investigate breaches are different from some authorities to others. For example, under the federal law, so under PIPEDA, the Privacy Commissioner will first try to, try conciliation, try mediation with the organization before giving fines. And as you can see on the slide, the maximum for customers will be $100,000. Now, in British Columbia, same idea, so mediation first before, issuing orders. And something also I need to highlight here is the fact that both federal authority but also British Columbia authority doesn't give fine themselves. So if, for example, there is no negotiation between the organization and the authorities, they will issue a binding orders that will be enforceable by a court. But it's not similar in Quebec. So Quebec has the same approach than in EU, so the authority is an administrative one that can directly impose monetary administrative penalties, even without necessarily trying to negotiate. So compared to the two others area, the Quebec doesn't have the obligation to try to negotiate first before before fining. And you can also see that the fines are way higher than in the other area. So for example, in Quebec, you will see that you can have up to 10 million of Canadian dollars as a fine, or 2% of your global turnover, so quite consistent. Now we'll finish with the compliance strategy. I mean, we will finish this part, of course, not the presentation. So we'll finish this part with the compliance strategy. So what to do when you have activities in Canada targeting more than one province, right? I think it's mostly why we are here. So first thing, you need to consider that you may apply the one-size-fits-all, meaning that you can compare and extract from all the provinces what is common, and then put optional wording to highlight the specifics per province in your SOP, etc. What happens if a provincial framework is less protective for data subject? You remember Giuseppe explained it, PIPEDA is the threshold of compliance. So if a provincial framework is less protective on a specific topic than the federal law, we apply the federal law. Concrete example, you have the fact that in British Columbia there is it's not a mandatory it's not mandatory, to perform a PIA. But under the federal law, it's kind of highly recommended by the authorities. So here we will follow the advice of the authority, right? And same for transfer. PIPEDA, as Giuseppe explained, PIPEDA apply per default, except if a provincial framework is more strict. But it can be more difficult if you are also an organization established in EU, because you will be subject to the GDPR also. So what we do here, first thing, Canadian patients will benefit from the GDPR obligations, but also from the Canadian one, because they are Canadian patients and they need to be protected under the Canadian law. What happens in case of potential contradiction or inconsistency? You, as a sponsor established in EU and also falling under the GDPR, you will need to prioritize the Canadian framework, because at the end of the day, the patients are Canadian. And I think I will give the floor to Giuseppe to conclude and providing you how we can support you at MDT.
Thank you, Winnie. And I think this explanation really highlight this aspect of fragmentation of the Canadian legislation. And in addition to that, I just would like to keep in mind this graph with the efforts related to the additional work in order to be compliant and the risk that you may be subject to. Sometimes small efforts for avoiding high risk. So remember that the devil is on the details. So what we call here nuances may be very important for your organization, for your compliance. So how MyData-TRUST as a data protection service provider can help you in this mission to be compliant with the Canadian legislation. But we can provide several services and we can act on different aspects for helping you to implement some organizational and also technical measures to be compliant with this privacy law. Firstly, we can identify all your activities that are within the scope of this legislation by doing a kind of assessment at the level, at the company level, I would say. Doing what we call here within MyData-TRUST the DPGA for Data Protection Gap Assessment, which actually will list all the processing activity in all your departments which involve the processing of personal information. And we will evaluate the current state of your privacy compliance for these activities. Obviously, it's not just to evaluate the compliance, but also to define what you need to implement, the compliance action that you need to implement in order for you to be 100% compliant with the Canadian privacy law. The register of processing activity is also highly recommended by the commissioner in Canada. The commissioner, which is the regulator of the privacy law in Canada. So which is this register, a mapping of all the processing activity that involve the processing of personal information. Again, Winnie already mentioned you and talked about the PIA, which stands for Privacy Impact Assessment. This assessment aims to identify what will be the risk of your processing activity on the concerned individual. The TIA will assess the risk, will identify the risk related to the transfer of personal information outside the original, I would say, province from where they have been collected. So it's important to note that PIPEDA does not limit the transfer of personal information, but they clearly mention that as per the accountability principle, which is the main principle as per the PIPEDA, the organization who have under its control personal information is responsible for the processing being done in a secure manner. So also when these personal information are processed by service provider outside the province from where they have been collected. So the organization will be responsible for the processing and transfer of this personal information. Also, a particular note for the Quebec, where we will have the provincial law that will be enforced, that will be applicable for the processing of personal information. For the Quebec law, the TIA is a legal obligation for organizations. We can help you putting in place an educational plan for your organization, so by doing workshop or training, introducing to your company maybe the key concept to respect in order to handle the personal information in a correct manner. We can help you to generate policies and procedures, keeping into consideration the security measures that are required when you are processing personal information. We can generate them, but actually we can also adapt, if you already have in your organization some procedure and policies which are, I would say, GDPR compliant. We can adapt and add some supplementary requirements to fit also with the Canadian requirements. We can help you also for your contract with the service provider to be, I would say, compliant, ensure that we have the adequate legal responsibilities of the party that are well mentioned in the contract. And finally, regarding the information that we need to share with the concerned individuals, we can also ensure that we have the adequate information for, by example, in the context of a clinical trial, for the patients involved in the clinical trial via the ICF, also in the notice, privacy notice that you can share with the study staff member, by example, in the context of your activities. And I think we can really cover several aspects and help you to implement all the things that you need to be to really pass this challenge to be compliant with the Canadian legislation. I don't know if you have something to add.
No, I think it was pretty clear, the conclusion here.
Clear. So we will maybe dedicate now a couple of minutes. Time is flying, but a couple of minutes if you have questions in the chat. Obviously, if you have a specific question or technical question, obviously feel free to contact us offline. You can subscribe to our newsletter, and it will be easy to contact us also via LinkedIn.
Okay, so I think we have a question. So can the DPO in Canada be fined, oh sorry, the question just disappeared, be fined as an individual for any breach committed by the company? No, it's not a matter of liability, right? So the privacy officer will not be fined as an individual, but it's a matter of accountability, because he will respond in front of the authorities. Like he will be the one requesting, answering requests from authorities, but he will not be fined individually. So it's not a matter of liability, but accountability, meaning that he will represent the organization in the discussion and in the compliance journey with the authority. And I think from what I see, it's the only question we had here.
Good. Good. Thank you very much for your participation. We're very happy to do this live for you and share this information with you. Do not forget one additional information, the US Data Privacy Summit that will be organized by MyData-TRUST in September. Please feel free to join this summit. It will be very exciting and interesting to share with you the last update regarding privacy in the US also. You can contact MyData-TRUST by contact@myData-TRUST.com, and we wish you a very nice evening or rest of the day for US people in the audience.
Thank you.
Bye-bye.
Bye-bye.